HorizonTV, the beacon for the nation. This program is suitable for general viewing.
A very good evening. Assalamu alaikum wa rahmatullahi wa barakatuh. Good evening, and my name is Feisal Kassim. Thank you so much for joining us tonight for yet another exciting, educative, informative conversation. We promised you, and alhamdulillah, tonight we are here to fulfill that promise. Again, ladies and gentlemen, our beloved viewers, it is time to get into the classroom, get your notebook, get your pen, and let's get into the class. Let's start getting our lesson. We have invited once again Commissioner Murshid Mohammed to come and talk to us about this whole institution of Qadhi Court. Last time he was here, that was 2 weeks ago, on the Live Real Talk. We spoke about the pre-independence Kenya and independence Kenya, how basically the whole coastal region became part of Kenya. He touched on the NFD, how it became Kenya, and he touched on how Kenya became Kenya, the independence constitution and the constitution that we've had after that, and the current constitution that we promulgated in 2010. And tonight, we are talking about the key subject matter that made us to start this whole series of the topic, the Qadhi Court. As you can remember, I just want to jog your memory. The Portuguese came way much before the British, according to what he told us. The Portuguese came way much before the British. But again, they tried to impose a system which the Kenyans, particularly the ones living at the coast, who were not Kenyans by that time, they sort of resented, they sort of repelled. So it did not work per se, and that made the Portuguese not to be successful at what is currently known as the Kenyan coast. Later on, the British came. And when the British came, what they said is that, okay, you guys have your ways of doing your things on your personal law. So what you can do is that we can just let you have that personal law, and we incorporate you into part of this bigger parcel that we have, that later on it was known as Kenya. So they were allowed to have their own governor, and then they were told to have a senator, which then would represent them in the larger Kenya, which was formed of other regions, the Nyanza, the Western, the NFD, to mention but a few. So tonight, this personal law that was governing the people at the coast at that time, which later joined what we call Kenya, this personal law is, in my assumption, I believe it sort of formed the Qadhi Court. And that is what we're here to find out. And if yes, then what is personal law? What does it entail? What are the jurisdiction, right? What made it successful to be in these successive constitutions that we've had? What are the do's and don'ts? What is in this Qadhi Court jurisdiction? That is what we're here to find out, and thank you so much for joining us tonight. Commissioner Murshid, Assalamu alaikum wa rahmatullahi wa barakatuh. I hope I'm a good student and I gave a good recount.
Yes, you did.
Alhamdulillah. Yes, that's amazing. Wallahi, thanks so much for making time for us once again this evening.
Okay.
Jazakallah khair. Now, we did a brief recount of events as per how you taught us in this live real talk class, you know, and we left it at the coast at that time, the 10-mile or the 16-kilometer coastal strip, joining now the larger part, or the Kenya, that's currently known as Kenya, with their personal status. And the question that I just asked even in the introduction, now this personal status, is this now what was later known as the Qadhi Court?
Yes and no. We are starting from the premise that even before the coming of the Portuguese, just like many other communities, they had their traditional setup,
yes,
their own conflict resolution mechanisms. For Muslims, that mechanism is well entrenched.
Yeah.
And it will be there in any Muslim community, anywhere in the world. Just walk into China, into Russia, wherever.
And it's universal, all over the world.
It's universal.
It's the same, yeah.
So that is what defined Muslims.
Now.
And that law is from the scriptures.
Now.
And from the teachings of the Holy Prophet ﷺ, which was an application of the scriptures.
Now.
And an explanation of the scriptures, scripture rather. So the Portuguese wanted to wipe it out, they couldn't. The resilience is very high, and not only can't the Portuguese wipe it out, nobody else can wipe it out.
Yes, okay.
Because it's a foundational matter. It's a faith-based issue.
No.
Now when the British came, like you have aptly said, they had to go with the flow. That they knew, they studied the Portuguese, which was a former power which was defeated. And they didn't want to face resistance.
Like the Portuguese did. So they learned from the predecessors.
So they recognized Muslim personal law. And the law that was being practiced was confined to the most important thing about Muslims and Islam, personal law.
Okay.
Issues of personal status, marriage, divorce, as well as inheritance. One critical thing which has fallen between the cracks there is about custody of children and upkeep of children. Which
I really want us to expound on it with time as we progress.
In a normal circumstance in terms of trying to think through it, especially when you link it with personal status. It goes without saying that children matters are also part of this package. And it was meant to be that way. Because when you talk about marriage, you know, the next thing involved in marriage is children.
So that's
the upbringing of children.
When you talk about inheritance.
Inheritance now becomes more specific, more isolated. But when you talk about the institution of family and the institution of marriage, and that of divorce, which is a reality, in between the married couple would be children.
Children. You cannot have those conversations without having the children.
Parents can separate, parents can divorce. And the issue of children need to be tackled.
Yes.
And the Muslim system, the Islamic system, has very, very clear parameters in terms of bringing up of children, whether the parents are still together, whether the parents have been divorced. That's personal status, which will take care of children read together with marriage and divorce. And then we also have inheritance. Now this, because it is a family issue, and Islam is very heavy on family, it became a core thing. And most of what used to take us to arbitration and whatever are issues around personal law. So much so that when the British came, they didn't want to touch that aspect of law. Because the British would come, they'll bring their common law principles. The way they treat family is not the way we treat family.
I just wanted to hold it there. And you've brought in a very, very important aspect, a conversation that I was having with another friend of the bar, and a practicing lawyer, basically. And a learned friend, so to speak, of which of course I'm not one. But, so apparently, common law as we're looking at is a conglomerate, is a collection of laws of the British from other areas. And for example, the whole transaction about land and business, it's apparently what the British established in India and business.
You know,
they brought it to Kenya.
They have a body of law. It is largely unwritten. Even in the UK, they don't have a written constitution. It is made up of conventions, it is made up of practice.
Yes.
That entire body of law is what is common law.
Yeah.
From the word common, it is common to everyone. It is common.
Okay.
It's common to everyone.
Yeah.
So whether it is on the issues around negligence, whether it is the issue around calculating compensation, liability, all that massive body of rules and regulations which regulate British society is called common law.
Okay.
And that's Commonwealth countries.
Yeah.
The same root is the common.
Yeah.
The House of Commons in the UK is the House of ordinary people, as opposed to the House of Lords.
Yeah.
So when you study law in any Commonwealth country, it is essentially the same law in all those countries which were ruled by the British.
Yeah.
Now, where did that body of law get itself from? Where is the jurisprudence?
Yeah.
You know, law is heavily based on religious beliefs and customs and traditions. The custom, traditions, beliefs of the British is actually Christian.
Yeah.
So we say Judo-Christian.
Judo-Christian, true.
And when we say that, when the British came, they would dispense the law from the lens of Judo-Christianity. And will try to view every native whom they ruled, be it in South America, be it in North America, be it in Asia and Africa. They would try to impose principles which they had articulated over time into those countries, and that is the situation even here in Kenya today. The training of the lawyers, which then become the judges, again is on those ethos. Now, it's when we have reserved the space for Muslims to apply Muslim personal law on matters of family, on personal law. That is where the principles, the ethos, the jurisprudence becomes radically different because of the historical aspect of it. That we were Muslims for centuries, 14 centuries
even
or so.
Before they came,
14 centuries or so. And that was what guided us. That is what we believe in. And the personal law, the family law aspect of it, being so integral for a Muslim. When the British, therefore, said, okay, you can practice your personal law, but other things like in the law of contract, criminal law, other civic law, that is going to be based on the common law. And in most of the countries which were colonized, they found it expedient to legislate on that law, to have it written down. And they would incorporate certain nuances of the natives, so long as it is not repugnant to them. Not to you, to them.
And it's not shaking the DNA and the structure of the common law.
Of them.
So
India got colonized way before. In 1948 was the independence. We got independence in 1963, 64, thereabouts. So they had developed a huge body of law in India, which they tried to clone in other colonies, Nigeria, Ghana,
South Africa.
South Africa in a sense, yes, but Kenya or East Africa. So we had in all other laws, now in our peculiar status, and even in India, they recognized personal law for the Muslims, and it's protected in India as we speak. but it is more pronounced in our part of the world. So it is now when we had to join with the Kenyan colony, the protectorate,
yes,
the coastal strip, which had its established way of life.
The personal
law in particular. So they said the Qadhi's court was agreed, and many other things, because we're not discussing that document. Otherwise, we would have made
the Shanti agreement, is it?
Yes, there's a whole lot of things and protections. So that's how the Qadhi's court was agreed to be in that document. And you see, it's a document where you exchange with sovereignty, with huge amounts of your rights. You are giving them up in terms of linking, because otherwise Kenya would not be having access to the sea. It will be a landlocked
country. It would have been a landlocked country without the coast.
So with the coast, it gained amazing
port and business
entrance, yes. And it rode on the past global linkages in trade. And so
actually, I think that was
today.
The sole means of trade, of exchanging goods between continents, right?
Till today, shipping
is one of the
carries more than 80% of the world trade. Yes, on shipping.
And today, it was, back then, I think it was, as I said, it was the main. By road would have been
absolutely.
Yeah,
there are no roads to speak of.
Yes,
but if you try to move goods by road or by train, there weren't any trains. You see, the lunatic line was built.
Yes,
when the British came. It's just the other day. So what we are saying is, because of that aspect of joining up and giving up, and what was given in return was a string of rights, which I wish we were discussing that one, but we can't. One of them, which is relevant to our subject today, is the Qadhi's court. So the Qadhi's court is not going anywhere.
So that's when it was entrenched in the first independence constitution.
It was there. Even as we carried on with a lot of constitutional changes.
So the constitution after that, to centralize the government, again it was there.
Again it was there.
It's only in this constitution that we had a big opposition.
Some trials were done to try to upset certain aspects.
Try and say then maybe you replace it with religious courts and not just Qadhi's court. Remember those?
It was, those arguments. But you know, there was a movement to say that all Kenyans must undergo autopsy before they are buried. That was fought out, and we prevailed. Then another infraction was when we said the Law of Succession Act will be applicable to everyone. To everybody, And there was a huge fight back, and the exemption was there. So the exemption kept being maintained. When we wanted to come in with the new constitution, there was a move of rejecting the Qadhi's court. But it was a very tough nut to do, knowing the historical aspect of it. And that's why it is also in the 2010 constitution. And to protect it further was to make sure that in our Bill of Rights, when we have the right of equality, we all enjoy that equality. Except when it comes to Muslim personal law, in those limited aspects, when it is on marriage, divorce, inheritance, and personal status, then that is limited to the extent necessary to protect the Islamic aspect of handling and dealing with these matters.
Guide me on this one. I think the marriage bill of 2013, even when it was passed, they had to put a clause that this law would not then apply to Muslims. Because they already have a clear guidance and strict of laws that are enshrined in the constitution.
And protected in entrenched and protected. And you know, it's an affair of Muslims. It does not involve anyone. Anyone else. We are subject to the same criminal law, the same civil law, the same procedures, except
commercial
on
law,
this very small aspect
the personal law.
Of the personal law.
Interesting. So one thing that I'd really like to get from you is about the jurisdiction.
Yes.
It's a very key issue and a very thorny issue in this case, because there's the aspect of submitting to the Qadi's court.
What that meant,
Yeah.
and those who were in charge of framing that aspect didn't do a very good job of it.
Okay.
Because once you say, if you submit to it, in other words, if you say that I don't want to submit to the Qadi's court,
so that means apparently,
then
according to the Constitution,
won't proceed to
yes,
the Qadi's
because
court.
you do not submit.
You see, so it was a massive lapse on the part of those who were in charge of navigating that area, because nobody pressed them that it has to be this way. So I don't know how they were guided or misguided, but I would like to believe that they misguided themselves.
Okay.
They couldn't come out and seek opinions of those who were more matured, probably, or more knowledgeable.
No.
People who had the far-sightedness
and more insight on the matter
of thinking around how and what complications this is likely to bring about.
Okay.
So it's like you can opt out of that one. But away from opting out, meaning that in the first instance, I don't even want to go there.
Yes.
I want to go to the High Court, for example, to deal with this matter
at the High Court level
of inheritance or of divorce.
Yeah.
Even then, the High Court would look into the matter and rule on it and act on it on the basis of what the Islamic
Sharia
law on that aspect
really
must take. That is what it is.
Wait, is this then subject again, as I said, to submitting to the court, or it is regardless of whether you submit or not?
Whether you say I am going and I don't want to go to the Qadi's court in the first instance.
Okay.
Meaning I will start the matter. I want to start the matter immediately in the High Court.
Yeah.
To rule on how are we going to inherit.
Yeah.
Who is going to be the administrator and all that. That law, which is to deal with that matter, probate and administration, that law itself exempts Muslims. And it is clear that when it comes to this issue, the Muslim law on inheritance is what is not applicable. Taking precedence means taking a higher than this one. There is no higher than there's no higher than anyone. It is
because
the
think
Islamic
about
law
it.
on
The Qadi's court is domiciled at the magistrate level of the court hierarchy.
Yes.
Then if you go and if someone decides he's not submitting to the Qadi's court, starts the case at the High Court, which is a higher court than the magistrate's court, and the judge is not well conversant with Sharia, which is the primary Sharia at the Qadi's court, then how does he go about it?
You see, there is this notion that the judge will seek the help of the Qadis.
Assessors.
The Qadis will be sitting through all those proceedings.
They should.
They do that. They do that.
Okay.
And the ruling will take into account the correct perspective and interpretation of whatever it is according to the Muslim law.
Okay.
Now don't get it wrong. It doesn't matter the religion of the court, the judge. Don't think that simply because you are a lawyer, you are a Muslim, you would have knowledge of Sharia law.
Yeah, that's why I did not specify religion. I just said maybe may not be conversant with Sharia law.
So whether it is Mohammed who is the judge, High Court judge, whether it is Peter who is, it does not matter.
Okay.
The entire proceeding will be hinged on what does Islam say in terms of sharing of this property of the deceased.
Okay.
And that will be applicable. So if a matter has gone to the Qadhi's court, which you are saying is the magistrate's court,
yes,
and any of the party is not satisfied with what the Qadhi has ruled,
yeah,
you have a right to go on appeal.
Yes.
And the appellate court becomes
the
the High Court.
Yeah.
But even as it goes to the High Court, now it's not going there for the first time.
Yes.
It's going there after having undergone certain deliberations and a ruling. It's going on appeal.
Yeah.
But even the arguments that will be there, eventually, the distribution of the property would inevitably be according to the way Muslims distribute their property.
That is if it has started at the magistrate's level.
Even if it has started at the High Court.
Okay.
It doesn't matter.
Great.
Yes.
So from what I understanding is that the wordings in the Constitution
yes.
about submission
yes.
is then what I can describe as the flowers of the Constitution?
It's not properly worded.
So you can say, that's what I'm saying.
That why should you have the discretion of submitting to a valid court of law?
If
you can just imagine if those who made that on the Qadhi's court were to go to the High Court level and say that people are subject to this court based on their willingness.
Exactly. So that's
absurd.
what I'm saying. Yeah, that's what I'm saying. One, can we say it is just a flaw of the Constitution? Wordings?
Yes, and those who were in charge of dealing with that aspect, they treated it as if it was some kind of a village thing.
Because I cannot today go to another, what do you call it, magistrate level court as something like, let's say, a tribunal, rent tribunal, let's say.
And say that I
do not submit.
I don't submit to this court. It is unheard of.
Yes.
And so it was at that point of time that there was technical imperfection by those, I don't know what they were thinking
the framers of the Constitution at the time.
It was like it is some kind of a village thing.
Okay.
And you sit around a fire. It is not. It's a proper judicial court where that idea that I may not submit to it just doesn't make sense.
Okay, great. Which we've clearly then established, amongst many other things, it handles the three key fundamental aspects: marriage, divorce, inheritance.
And personal status.
Personal status.
Yes.
I think the three come under personal status. Is that correct? Is my interpretation
no, personal
correct?
status may be part of what informs these other three.
Okay.
But personal status, let's try to understand it. It is what makes you. That's personal status.
Example?
For example, the Sikh community.
Yeah.
Even in the army, even in Europe, they'll be allowed to wear a turban.
The turban, yes.
That is what makes him Sikh. If you remove the turban from him, he is no longer what he is.
Yeah. The Rastafarian.
For a Muslim lady,
yeah,
the hijab, which is not a headscarf.
Yes.
The hijab is a total apparel, which does not warrant you to reveal your contours. That's the hijab.
That's true.
Now, without that, and you say, take off the hijab, remove it when you enter these school premises, whether it is public school or private school. That's an infringement of somebody's rights in terms of personal status. For example, you have in a school, and you have Muslims in the school, and you say that we'll make these meals where we can also serve pork. Muslims don't eat pork, so you can't force them to eat pork. You are infringing on their rights. You are infringing on their personal status.
Wow.
So, in regard to personal status, it is about what really makes you a Muslim.
Your identity.
If you are telling me that I cannot build a mosque, I cannot call the adhan or the muezzin, I cannot go for my 5 daily prayers, you are infringing on my rights on my personal status,
which
also has found expression
yeah.
in other aspects of the Constitution, which tells us the freedom of conscience, freedom of religion.
Yeah.
So I don't see how we start imagining that this freedom of conscience and freedom of religion can be half applied to Muslims, as if you are people who, you know, can be pushed around.
Because maybe if, I always say maybe we have self-marginalized ourselves.
Yes.
And one thing that I'm really understanding, I'm really getting from this conversation tonight,
yes.
is the breaking down of the whole personal status aspect. If you recall, even the case on hijab,
yes,
it was based and it was anchored on the Bill of Rights.
Yes.
And it was...
You are telling me I have freedom of choice.
Yes.
I have freedom of religion.
Yes.
I have freedom of conscience.
But at the same time, you're trying to infringe.
At the same time, you're telling me you can't put on your hijab.
How I wish the lawyers then would have used the aspect of the personal status, because then it would have gone on record as a precedence.
I think they did.
Did they?
But when you have training on the part of legal officers, which will include judicial officers,
yeah,
on seeing things from jaundiced lens of Judeo-Christian values,
yeah,
on people who don't ascribe to those values,
yeah,
particularly when it comes to their personal laws.
wow,
that is where the problem is. And you have this kind of thinking, and you know, always this is the case. There is always an onslaught on minority rights the world over.
Yeah.
Whether it's a Muslim-dominated country, whether you have a country which is close to a nation, you know, these things are different.
Yeah.
You'll find those, even if you belong to the same religion, there will be aspects of people who can be marginalized.
Yes.
And you know, there is this thinking that it is okay to ride roughshod over people who are marginalized,
yeah,
or who are in the minority status.
Yeah.
Yeah. So once again, it's that lack of finesse, elegance,
yeah, yeah,
in doing your things. It's also partly prejudicial.
Which also makes me think.
Yes.
Again, taking part in this conversation and being in the information sector, I've interacted with the Qadhi's court, I've interacted with the Qadhis, I've interacted with the legal practitioners, both Muslims and non-Muslims alike. I've interacted with officers of the court, talk of judges, talk of, you know, some of these officers. And what I'm understanding from this conversation is that there is seriously deficiency of information.
Yes.
And understanding.
You're quite right. And part of the problem are the Muslim professionals.
That's what I want to come to.
Yes.
There was a lot of civic education before the promulgation of this new constitution.
Right.
And I remember the constitution was even printed like a newspaper.
Yes.
And they had people moving around
Absolutely.
Vijijis to train people. But did the framers, or did you, the professionals, the way you're explaining to me right now the whole aspect of personal status, did you take time to take the custodians of this constitution through it well?
You see,
for them to understand it well when they, when they're issuing their judgments.
Correct. You see, the problem is, like I told you, let's point inwards. We, the Muslim professionals, scholars, we dropped the ball. We had a very good constitutional and protections. Let me not confine it to just Muslims. Kenyans as a whole. You see, the Constitution is a framework. It's a document which has a vision for change. It gives you the basic requirements for that change. And you'll find after every substantive chapter of the Constitution, be it rights, be it land, be it the economy, there would always be something at the end of it. Parliament shall enact legislation to give effect to these ones. And whom do we send to Parliament?
The most popular.
So, if we choose our MPs the way we elect them, some of us bring MPs who have absolutely no skills, no knowledge, no history, no constitutional thinking, no constitutionalism, and we give them a position. It's like giving a tuk-tuk driver a Dreamliner to fly. It will not even make it 10 meters just on the ground. So where we lost our way, I'm now talking generally as Kenyans,
yes,
is implementing the Constitution. The first point of implementation of the Constitution is to make enabling legislation. Because the Constitution is a very small document.
Yes.
If you look at the laws of Kenya, they will fill up all these shelves from the entire length of the rooms. Those laws are now what must be in line with the Constitution. We had inherited many colonial relics, which had to be amended, or they had to be removed completely and done afresh. You and I can't do the job. That is the job for the members of parliament, particularly of the National Assembly. Now, those are canvassed through political parties. What is the orientation of the political parties? Are they democratic in character?
Not really.
Do they know the ethos of the Constitution?
I doubt.
You put an MP in charge of such a big vehicle, he knows very little history of where we are coming from. He knows very little about the struggle, starting from the colonial struggle and right through the struggle in the building of the nation. So I'm not about to put blame only on those aspects of the Muslim lawyers and scholars in terms of implementing and furthering.
Even understanding.
Yes, furthering the rights that we have been given on the personal law. We ought to have done so much. We have to have fleshed out what is personal status. We should have incorporated the issues of children and influencing and be part of the conversation of the Children's Act.
Yes.
Because there are certain aspects which are not in line with the Islamic family setup. And if you take time and you look at the heavy responsibilities on the parents in terms of bringing up of the children, I can challenge any other law to show how close is it to this particular law without being prejudiced to anyone.
There is none.
So we needed to have developed that. The idea of the Qadhi's court being a magistrate's court, how could we have developed it to have an appellate system that again is only for the purposes of the Muslim personal law? You know, we have the right of appeal. It's a constitutional right, it's a fundamental right. Have you not denied this right of appeal?
You have.
To a huge section of the Kenyan population? You have.
So but what again, have the people who are supposed to see that,
what have we done?
See that lacuna, that gap in the law, they're busy trying to, quote unquote, just deal.
And still it is not lost. We still, nothing stops us from conversing and putting up legislation to speak on personal law. What is this personal status? How is it applicable? How are we going to deal with a matter which has to go on appeal? What are the procedures? Why can't we put a substantive law which governs
to operationalize it,
so that even a court that is itching to try to push
about it,
to push limits until they reach a breaking point, to make sure that they are within the straight and the narrow, because the work of the court is to apply the law.
Yes.
Once they read the law, they give interpretation to the law. But if you give something that is not defined, something that is loose, you give a lot of room towards bringing in interpretations and trying to say, now this is how I see it.
And
this is how I'm going to rule on it. And without being cautious not to speak on anything that is already before the court, we are speaking in general terms.
Yeah.
So again, we have our parliamentarians. What stops them from saying, let me sit down with the community, with the scholars, with the qadis?
Because clearly you've already said
Yes.
the problem where the problem is. They do not have the intellectual acumen.
Yes. Even
to
if
look into the matter.
even if you have that deficiency, you can ask those who know.
But again, is it a priority to them?
But most MPs, not all of them, think that because I am the MP, I become the cleverest person in this room.
That's what I'm saying. So is it a priority to them? Is it something that they actually see it as an agenda, as an item?
So I call upon the Muslim scholars,
You
Muslim
included?
lawyers. No,
You included?
Muslim scholars have an elevated, then it comes with training and all. The lawyers who can now really key into that knowledge, bring up pieces of legislation to govern Muslim law on marriage, on inheritance, on divorce, and on upkeep, maintenance, custody of children. On those limited aspects, bring up. I don't see any resistance to it by fellow parliamentarians because it is something that is part of the Constitution. So, where are they? I can count over 100 or so. So it's a challenge we're posing to them. It's
My
a challenge.
question I'll ask you
Yes.
is, where are you?
Yes.
Not where are they, where are you? Because
I
would put you as one of those scholars.
And that's why I said that everyone is to blame.
Yeah.
Whatever is happening today and has happened in the past should be a wake-up call to galvanize people to establish and protect their rights and give furtherance to the Constitution. There are certain things that can be dealt with administratively.
Yeah.
There are certain things that can be dealt with by making the law. There are certain things that can be done politically. So do we have this
structure that will address all these
that will be addressing
facets,
this?
yeah.
Do we have early warning systems when something is coming in through legislation and it has an impact on certain rights which would affect Muslims legitimately as Kenyan citizens? Do we have that early warning
Not
systems?
really.
You guys, this is what is happening. Let me have a conversation. Go back to Parliament. Try to see that it is not going to affect adversely because we have rights. For example, just I'm taking a hypothetical example. Is HELB Sharia compliant?
Not really.
Can Muslims then say that I can go to HELB and be charged interest? So if I want to stick to my faith, then I won't take that loan. Is that how it's supposed to be?
No, that means you're missing out.
Are you not a taxpayer?
You are a
not
taxpayer.
Kenyan?
You're a
Are you
Kenyan.
not entitled?
You are.
So what's
Is it not infringing on your...
What's the big deal in saying that we have to do some Sharia compliance on this one? Because even the central bank has accepted Sharia compliance. We even have very strong banks which are Sharia compliant, which again, Muslims and non-Muslims. Yeah?
Can I bring it closer home?
Yes.
If I bring it closer home, this administration running up on better, that is bottom-up economic transformative agenda, one of the key things they came up with was the Hustler Fund, which has interest in it. So are Muslims allowed to take part in it?
You're locked out. You're locked out.
Oh my goodness.
So, unless you say now, I don't care about my religion, I don't care about my consequence, I don't care about God, which is absolutely not the case with Muslims. And because of that, keep losing out. Who has to rectify it? Not me and you, even through the media.
But we can start the
or
process.
write-ups. It's supposed to start and end with our parliamentarians. Who are there in Parliament?
Let's start the process. Commissioner.
Good.
This, oh my goodness. Again, this is another classic session.
No, thank you.
Thank you once again, Commissioner.
You're most welcome.
And the challenge that I'm picking tonight is, where are you?
Yes.
I'm trying to do my part by having this conversation.
And where is everyone?
Where are you?
Yes.
Where are your colleagues?
Yes. Yeah.